Ready. 5 seconds. Start. The petitioner was appointed as lecturer in mathematics in the Institute of Engineering and Rural Technology, Allahabad on 6th September 1983. Full stop. The petitioner's wife, Dr. Sarita Srivastav, joined as a lecturer in Sanskrit in the Rajashri Tandon Mahila Mahavidyalaya on 31st March 1989. Full stop. Both the petitioner were receiving house rent allowance from their respective institutions till January, 1996, when the house rent allowance of a petitioner's wife was stopped by the principal on the ground that she is not entitled to receive the same since her husband is already receiving the house's rent allowances. Full stop. The petitioner gave in writing that the house rent allowance to the petitioner be not paid and the house rent allowance to the petitioner's wife be restored with effects from March, 1996. The house rent allowance of the petitioners was stopped and that of his wife was restored with effect from March 1996. Full stop. The petitioner submitted a representation on 17th February 1997 to the director, capital IERT, full stop, seeking payment of house rent allowances as well as arrears of houses rent allowance on the strength of the division bench judgment of this court in the case of Dr. Maya Rani Srivastav versus Director Higher Education UP Allahabad and others, capital AIR 1998, capital SC 157, full stop. The petitioner submitted reminders, full stop, the directors, capital IERT by order dated 5th September, 1997, directed for payment of house rent allowances to the petitioners in pursuance of which the joint director, technical education Varanasi started payment of house rent allowances to the petitioner from October 1997. Full stop. The petitioner therein after submitted that another representation for payment of arrears of a house rent allowances from March, 1996 to September 1997. Full stop para. On such representation of the petitioner, the director, technical education wrote to the state government seeking appropriate direction for stopping the house rent allowances of the petitioner, full stop. In the reference letter dated 11th July 2000 of the director, technical education, it was stated that when husband and wife both are residing in the same city and in the same house, both are not entitled for house rent allowances, and the judgment of this court in Dr. Maya Rani case into bracket supra cannot be applied in all matters, full stop. The state government wrote a letter on 21st October 2000 to the directors, technical education after receiving which letter, the director, technical education issue an order dated 10th November, 2000 for stopping the payment of house rent allowances to the petitioner and for taking steps for recovery of irregularly paid houses rent allowances to the petitioner and further to submit a report of responsible official in that regard. Full stop. This writ petition has been filed by the petitioners challenging the aforesaid order, full stop para. In the counter affidavit filed by the state, it was stated that in view of the clear policy of the state, that is husband and wife both are in the government service, the house rent allowances is not payable to both of them, hence the order issue were perfectly in accordance with law and the petitioner was not entitled for payment of house rent allowances. Stop.